Cahoe's here. Jim Dinsmore's here. Jim's the, you might not have met him before, but he's the Conservation District rep to the steering committee and then the task force.
Okay.
And then Jay Wiener is here from the state, and Dick Mata is here, and Elena Gagliano. And that's what we have. And I said Mike, right?
You did.
Okay. Okay, so whenever you're ready, Jay, come on up.
All right, thank you. I had PowerPoint, but I don't think you guys need it, want it. I have a projector in the car if you want it, but otherwise I can just talk.
You want to look at a PowerPoint, Scott, or are you good?
No.
Okay.
Okay. There we go.
Just to keep the public out.
It's good reason.
Yeah.
So, okay, so on the phone, I should have said, is Susan Callahan.
Jay Wiener.
Hi, Susan.
Hello again.
Okay. Sorry, that was my bad. Anyway, Jay's here to talk about the Reserved Water Rights Compact Commission's work on the, what do we call it? The negotiations with the Confederated Salish and Kootenai tribes.
That I am. Thank you very much. I really appreciate the opportunity to come and visit with you. We are trying to move forward with the settlement with the tribes that we can take to the Montana legislature in January. We've been working on this settlement off and on for 25 years and in earnest for a good 5 now. And we are cautiously optimistic that we are approaching the initial finish line. The settlements that we do, the agency that I work for is the Montana Reserved Water Rights Compact Commission, which is a little agency down in the basement of DNRC. It's attached to the DNRC, but we actually negotiate directly on behalf of the governor. We were created in 1979 by the legislature as part of the adjudication to negotiate out water rights settlements resolving the claims of tribes and the United States for lands in Montana that have what are called Federal Reserve water rights. Federal Reserve water rights are water rights that are created under federal law, as the name suggests, and they sit in awkward tension with the water rights that y'all are probably more familiar with, statewide-based water rights. Montana is a prior appropriation state, and the basics of the prior appropriation system are first in time is first in right. So a senior right is entitled to the last drop of their water before a junior is entitled to the first drop of his. And the measure of the right is use, is beneficial use. Sounds like I'm
Hang on a second.
beating back a little
Susan,
bit.
Yeah?
your phone's making kind of weird noises here.
Is that better?
Yes? Okay.
Great. And the measure of the right is use, so how much you're entitled to is how much you've historically put to use. These Federal Reserved rights sit in awkward tension with that because while they're designed to exist in the priority system, they're not measured based on use. The priority date associated with Federal Reserved water rights is the date that land was taken out of the public domain and set aside for a federal purpose. So the date that the national forests were created, or a wildlife refuge, or a national park, or in the case of Montana's 7 Indian reservations, the date of their treaty with the United States, which in the case of the Confederate Salish and Kootenai tribes is July 16, 1855, which makes it a very senior water right in Montana's priority system. The other piece is that the right's not measured by how much water is actually being used, it's measured by how much water is necessary to satisfy the purposes for which the land was set aside. For national forests, for national parks, at least we can go back to the organic acts that Congress passed creating those things and look at it. We had a long and contentious negotiation with the Forest Service that concluded with a compact that we've got ratified by the legislature in 2007. And one of the reasons that took so long is the Forest Service kept saying, hey, we are ecological stewards and we want water rights for in-stream flow. And we said, well, that's nice, but the Organic Act that created the Forest Service essentially made y'all tree farmers. And you don't get in-stream flow water rights as your Federal Reserve water rights. You get enough water to keep the trees growing, to satisfy, for your campsites, for your administrative sites, but not for in-stream flows. And they ultimately conceded the point and we were able to reach a settlement. However, for the purposes of an Indian reservation, and I'm sure I've used this line here before, so I apologize part of it. But that's what we call a lawyer full employment question. It's not clear when you look at some of these treaties what the purpose or purposes was that the land was set aside for. And so trying to figure out how you come up with an amount of water for these Indian reservations is a complicated task. Made all the more complicated by the fact that they're sitting there with oftentimes the senior-most right on the system. And so if you take a new use and you slap it online at the head of the queue, you've got potentially some really significant impacts to everyone else who's been relying on water for the last 130, 140, 150 years. And so the legislature created the Compact Commission to reach negotiated settlements in a way that we could recognize the tribe's legal entitlements to water, saving them, therefore, the risk, time, and expense of having to litigate to prove up their water rights claims, in a way that would allow us to protect existing users to the greatest extent possible. The commission was created in '79. It was originally due to sunset in 1983. That didn't actually stick. We've been extended several times since then, but we are now due to go out of business on July 1, 2013, and we are planning on actually being one of those few government agencies that really does put itself out of business. We've got 3 settlements left to do, 2 out on the east side with the C.M. Russell Wildlife Refuge and the Upper Missouri Breaks National Monument. We expect to have both of those ready to go to the legislature in January. And then the Confederate Salish and Kootenai tribes is the last one. Over the last 30 years, we've done settlements with the 6 other reservations in Montana, Forest Service, Park Service, the rest of the National Wildlife Refuges in the state, the BLM, and we think it's been pretty successful because we have been able to negotiate for the protection of existing users while we work out these water right deals that ultimately we can take to the water court and have decreed along with everyone else's water rights in the adjudication. So that's how we're here and why we're here, in general terms. Why I'm here in Phillipsburg today and why you all need to be paying attention to this, where the Flathead Reservation is out there north of Missoula, is that unique among the tribes in Montana, the Confederate Salish and Kootenai tribes have very strong legal claims to water rights off their reservation. The rest of the tribes, when they signed their treaty with the United States, they gave up all lands off the reservation. They largely restricted their rights to on the reservations that they retained for themselves. The CSKT, however, the treaty that they signed, which they signed with Washington Territorial Governor Isaac Stevens in 1855. And Governor Stevens signed a whole bunch of treaties in the 1840s, 50s, and I believe into the early 1860s with tribes in the Pacific Northwest. And CSKT is the easternmost tribe that signed one of these treaties with him. And all of the treaties that Governor Stevens did with these tribes have language in them recognizing that the tribes, as part of what they're giving up and then as part of what they're keeping, are retaining the right to hunt and fish at their usual and custom locations, whether those locations are on or off the reservation. That's the legal language. It's in Article 3 of the Helvey Treaty. And courts have, over the years, interpreted that language, not so much in litigation arising out of Montana, but in litigation out of Oregon and Washington with tribes who have the same treaty language, to hold that that right to hunt and fish in a usual and custom location, or that right to fish, brings with it an entitlement to keep water in the stream, so that there are in fact fish for them there to take. And so that's created a unique challenge for the Compact Commission because it's dramatically broadened the geographic area that we need to be worried about in our negotiations with the Confederate Salish and Kootenai tribes. We need to settle their water rights on the reservation, and we need to settle their water rights claims off the reservation in a way that we feel is politically viable, which means that it can't simply disrupt all water use in western Montana. And so as we sat down, really started about 4 years ago, looking at where we thought the tribes might have colorable claims to water and what we know about the water supply, the water budget, the current demands, projected future demands, what resources there are in play in western Montana, we started trying to figure out, well, how are we going to do this? And what we did is we identified several basins, and they're major western Montana basins where the tribes do in fact have colorable legal claims and demonstrable cultural ties. And that's the Kootenai, the Swan, the Flathead, the Clark Fork, and the Bitterroot, which is most of the major waterways in western Montana. And we looked at each of those systems, each of those waterborne basins, and we looked at how much water was there, and we looked at how much current use was there, and we looked at what other protections were in place. The Forest Service compact that I talked about does build in some stream flow protections. They are all limited to the forest boundary. But we came to a compromise with the Forest Service in a way that allows them, under state law with junior priority dates, to provide some flow protection. And so we looked at those. We looked at where Fish, Wildlife, and Parks in-stream flow plans and recreation rights plans are. We looked at where stored water was, particularly down in the Bitterroot out of the Painted Rocks and Lake Como. And looking over here, we saw the Milltown Way. Because ultimately what we proposed to the tribes, and we originally put this out there last summer, we refined it in January, and the tribes responded to us about it in May. All of those documents are up on our website. I was down here a couple of times, I think in June, talking a little bit about that. But ultimately what we realized is that there was not a one-size-fits-all solution that was going to work off the reservation in western Montana to come to a politically viable deal. Up in the Kootenai, over in the Swan, there's a pretty healthy amount of water. There are a couple of very large dams that regulate the flow, and there aren't a whole lot of existing uses. And so what we felt that we could do was for those streams, and actually also on the lower Clark Fork, the tribes came back to us with a request for the lower Clark Fork, but to recognize a time immemorial, which is what the treaty language entitles them to, which basically just means they're first in time period. Nothing is older than that. But a time immemorial in-stream flow right on the main stem of the Kootenai, on the main stem of the Swan, and on the main stem of the lower Clark Fork. And we picked those locations, and we picked the measurement points very carefully, and we identified the enforceable flow levels very carefully, so that we believe that under all the conditions that we've seen, looking back over the 50, 60, 70 years we have records, we took a look back before Libby got put up on the Kootenai to see what things look like. And we were of the opinion that with the enforcement points that we've chosen and the flow levels that we've chosen, all of those rights can be satisfied in a way that does not disrupt existing use. So we think that's a viable approach for us on those three streams, the Swan, the Kootenai, and the Lower Clark Fork. That doesn't work in the Bitterroot, and it doesn't work in the Upper Clark Fork. Both those basins are closed because they're already over-appropriated. There are already huge demands for water in them. And introducing a new tribal senior in-stream flow right was just not something that we thought was going to be possible. So down in the Bitterroot, we proposed making the tribes essentially beneficiaries of contracts that Fish, Wildlife, and Parks already has for the delivery of stored water from Painted Rocks and Como. And we figured that would work because Fish, Wildlife, and Parks' interest, and the reason they have those contracts is they put money up for the repair and the enlargement of those dams over time. And they manage that water to provide particularly late season fishery flows when the main stem of the Bitterroot's otherwise running low. And we figured that that was identical basically to what the tribe's interest down there was likely to be. Those contracts are already in place. The Bitter Irrigation District folks are used to dealing with it. And we proposed those as a way of trying to essentially reach a political compromise with the tribes. It wasn't going to be more water for them, but we didn't see where more water was possible to be had. And they have basically agreed to accept that as an approach. And then in the Upper Clark Fork, what we looked at was the Milltown Dam water right. And the reason we looked at the Milltown Dam right is that the state already owns that right. We acquired it under the natural resource damages litigation with ARCO and Northwestern Energy. And under the terms of that settlement agreement, one, if the state was going to take the right, they were going to need to use it for restoration purposes. And two, if the state didn't take the right, the next folks in line to acquire that right were the Confederate Salish and Kootenai tribes. So Montana exercised its option to buy that right. The Natural Resource Damages Program put up the money required under the settlement agreement to buy it. And the plan is, leaving aside this water right settlement entirely, the plan is for that right to go to Fish, Wildlife, and Parks to use for in-stream flow purposes. So we looked at the fact that the Milltown right is coming one way or another, and we thought, okay, let's see if we can use this in our settlement. And that gives us a couple of opportunities, different from having Fish, Wildlife, and Parks just take the thing through the DNRC change process, come out the other side of the change process whenever it comes out the other side, with a right that it's simply free to enforce. Because we thought that bringing the Milltown right to the table, since the tribes clearly have a demonstrated interest in it, they actually petitioned to intervene in that litigation with ARCO and were granted the right to intervene in that case because the court found that they were in fact natural resource custodians, essentially. That the court found they made enough of a showing of their historic and cultural connections to the Upper Clark Fork to be entitled to intervene in that litigation. So that's a very strong indication that were we not to reach a water rights settlement and were we to go to court, the tribes would be well positioned to make water rights claims up here that we think could be very disruptive. And that's exactly the scenario that we're trying to avoid. So we looked at the Milltown right, and we also said, look, it's going to be a cumbersome thing for Fish, Wildlife, and Parks to take it through the DNRC change process. That change process is not the most user-friendly process in the best of circumstances, and it's not real well set up to make an evaluation of changing the purpose of a hydro right to an in-stream flow right. And so what we said to Fish, Wildlife, and Parks is, look, if you are willing to live with some constraints on your exercise of this water right, you're not going to come through this with a free and clear 2,000 CFS water right that you can exercise however you see fit, which is what the water right is. It's a flat line 2,000 CFS every day of the year water right with a December 11th, 1904 priority date. So it's not the oldest right in the system by any stretch, but it's certainly older than at least half the rights that are out there. Somewhere about roughly about 2/5 of the rights that are out there are senior to Milltown, and the rest are junior. And we said, look, that has potential to be fairly disruptive in its own right if we're going to do this in the settlement. If we're going to ask the legislature to make this change rather than have you go through the DNRC process and take your chances there, we need y'all to give something up to make this work. And so what we proposed is to keep the right at a 2,000 CFS number for legal availability purposes. So if at some point in the future the Upper Clark Fork Basin is reopened, right now it's legislatively closed, but if at some point in the future we're reopened to new permit applications, if you're going to make a showing of legal availability of water, which is one of the things that you have to do to get a permit under the Water Use Act, you need to account for that right at 2,000 CFS level. But we said for enforcement purposes, for purposes of making a call, we don't believe that that flat line number is going to work, certainly not during the irrigation season. And we said that we're going to come up with what we call an enforceable hydro, which is looking at the flow statistics that we have, looking at the period of record, a number that allows you to avoid essentially dewatering the stream and making it really hell on fish, but isn't such a huge number that it's everything every fish biologist in the world might want. And that goes to the goals that Montana had as we put our off-reservation proposal together, because we were trying to juggle four things. We were trying to protect existing users, we were trying to come to a negotiated settlement with the tribes, we were trying to provide ecological restoration benefits for western Montana, because that's an important part of our economy these days, and we were trying to make sure that there was still room for new permitting where that was possible. That was a bigger issue on the Kootenai and the Swan than it is here on Bitterroot, because those basins aren't closed. But again, we wanted to try to look to the future as well and not preclude the possibility of finding new water for future growth and development, which we all expect is going to happen at some point. And so we tried to balance those things out, and we came up with a proposal that essentially chopped down the irrigation season numbers for that right to 1,100 CFS. That's what we proposed. Tribes came back and said, we think 12 is better. And frankly, we were pleasantly surprised that the tribes came back at 12, because what FWP told us based on their wet and perimeter methodology is that they thought 1,300 CFS was an important inflection. That was their preferred number for fisheries. So the fact that tribes came in essentially splitting the difference between us and FWP was a signal to us that they were interested in approaching this constructively.
What the landowners want.
Landowners want as little as possible. Landowners like nothing. But again, that comes to the fact that Milltown right is counted in some fashion. And what we did when the tribes came back to us at 1,200, the other thing the tribes came back to us with, in addition to the 1,200, two other things actually, was one, a proposal to formally bifurcate the right. So what we proposed is 1,100 measured at the confluence of the Blackfoot and the Upper Clark Fork, right at the old dam site where the USGS meet together. Exactly, right below the confluence, yeah. And what the tribe said is, Blackfoot puts out a certain amount of water, and Upper Clark Fork puts out a certain amount of water, and rather than being able to say that you can take that whole 1,100 that we proposed and call for it just up the Upper Clark Fork or just up the Black Fork. They said, we think that a reasonable thing to do at this 1,200 number that we like is to have a 700 CFS target out of the Black Fork, measured at Bonner, and a 500 CFS target out of the Upper Clark Fork, measured at Turtle. So you're looking at that, essentially, in the way they proposed it, is a max of 500 CFS during the irrigation season at Tura for what the Upper Clark Fork has to come up with.
So if they have that or don't have it, then they can go upstream and start shutting off places to get their flow before other people get theirs.
That's where I'm going there next. If you get the if you fall below 500 at the Tura gauge, that's what we're doing. Let me do one thing first, which is that the other thing the tribes came back to us with is a proposal of a deferral payment. What we were doing is proceeding from the assumption that, look, the state already owns this right, FWP wants to enforce it, this right's going to be enforceable from day one, so we got to get the flow levels right. What the tribes came back and said is, we want this a little bit of a higher level, but we're willing to wait 5 years before that is enforceable so that folks on the ground could try to figure out what that's going to look like. The Blackfoot's done a lot of the Blackfoot Challenge, they've done a lot of adaptive management planning, a lot of drought planning. The Upper Clark Fork hasn't. And the tribe said, look, use this period of time to do some planning in the Upper Clark Fork. We said, that's a really good idea. We think 5 years is probably too short because the Upper Clark Fork and the various tributaries look a lot different than the Blackfoot. We think 10 years is a more appropriate number before this right can become enforceable, to try to figure out what it might look like, to try to figure out if there are other management fixes that could be done, other sources of funding to try to improve efficiencies could be done, other sources of water. Folks are talking about silver, whether there's additional sources of water that could be found to ensure that that enforceable level gets hit. We don't have the ability through the compact to ensure any of those things, but we can certainly make sure that we're not precluding them, and we can try to buy some time for folks to explore them to see what might happen. So we said to the tribes, we're willing to go with the 12, with a 10-year deferral period. And the tribes said they could live with that, which is what's reflected in the draft compact that's up on our website as of last week. The other thing that we said, two other things that we said, and this goes directly to the enforcement question, is, okay, who can you enforce against? And we said, first of all, we don't want to see this right enforced against non-irrigation users. By and large, they're smaller, you're not going to get a whole lot of water from them, it's not going to be efficient to make a call against them, and we would just like to take that entire category of concern off the table. You're not going to call hydro rights, you're not going to call municipal rights, you're not going to call domestic or stock rights. As a practical matter, you're not going to do it anyway. Let's just take that possibility off the table because that helps make this more politically powerful. Frankly, now that was the candid conversation that we had, and the tribe said, okay, we can live with that too. As actually did Fish, Wildlife, and Parks, because what we're proposing is both the tribes and FWP to jointly own this right. Because it's one right. We're not talking about doubling the right where each can enforce it. We're talking essentially about they'll have an obligation to coordinate with each other, but if they can't agree, each one could independently exercise it. It's no different really than if you and your brother inherit a right from your dad. You guys are both on there as the owner. It's still one water right. And you figure out as best you can how to exercise it. If you can't, then you fight over what to do with it. And that's what we're proposing for the tribes and FWP to have as well. The other piece on enforcement, two other pieces really on enforcement. One is the no call against non-irrigation users. The second piece is that we said that, okay, if you want to call irrigators who are junior to your priority date, because this is still operating in the state-based system, we're not creating a Federal Reserve water right. We're not changing other than reducing the enforceable and changing the purpose from high grade in-stream. We're not changing the fact that the Milltown right is a state law-based water right that exists in the state priority system like every other right. So we don't have the ability to simply, essentially put the Milltown dam right at the back of the law. The tribes weren't going to accept that. Fish, Wildlife, and Parks weren't going to accept that. That actually probably would violate the conditions of the consent decree with ARCO, so we just couldn't do that. Because that consent decree requires us not to do anything that diminishes the value of the right. We believe that these conditions on the exercise of the right don't diminish the value because they allow the change to be done through the legislature instead of by the NRC. We think legally that's a reasonable and a valid thing to do under the consent decree, but we also recognize that we are getting up close to the line where we run into trouble with the consent decree, and we can't do that. So we've got junior irrigators potentially subject to call, and we wanted the irrigation right junior to December 11, 1904. The one other piece that we built in to protect those folks is to say that you can only make call if that flow target, 500 CFS at Tura during the irrigation season, 700 CFS at Bonner during the irrigation season, doesn't get hit for 5 consecutive days. It's not the sort of thing where you get the right to call the second it blips below that number. It's got to be a sustained drop. And some years, that water's not coming back whether you call for it anyway. Some years it's sufficiently dry that once it drops, it drops. And no amount of enforcement action is going to bring that water back up. Some years, maybe you can. And so that is what we put together as how we're proposing to use the Milltown Dam right as a part of the settlement. It's reflected in the draft compact that we just put up on the website. There are a couple of appendices there, appendices 26 and 27 specifically, that are the proposed abstracts for that split right. So we've got the original right that's there. We would change the purpose of that original right, and then that essentially would become the parent right in the DNRC database. It by itself would not be enforceable because it's 2 child rights. The one on Bonner and the one in Tura would be the enforceable versions of the rights, and those proposed abstracts are also up on our website. So that's how we're looking at it. We looked closely at the flow statistics and when the likelihood of call would occur. We thought about being willing to go from 400 to 500 in Tura. We wanted to make sure that that wasn't going to put a whole bunch of new folks in the world of hurt, because otherwise we wouldn't have done it. And what we discovered as we looked at the records we have is that at the 400 CFS level, you're looking at the possibility of call probably 3 out of every 10 years. Those are the driest years. At which point
3 out of 10?
3 out of 10. Yep, that's what you're looking at. And in those years, you're looking at calls starting potentially mid-August, and in the worst of the worst, potentially as far back as sometime in July. Going from 4 to 5 brings roughly 2 more years out of 10 when call might happen. But those 2 additional years, you're talking about a couple of days in September. You're not talking about a meaningful bite into the irrigation season, and we felt that grabbing a deferral period idea was worth that trade-off. And that's how we looked at it. We also took a look at what it looked like on Flint Creek and on Rock Creek and on Warm Springs and the various tributaries, because one of the ideas that was originally floated was, rather than having it be just an aggregate number down at the confluence of down in Tura, have essentially individual contribution targets for each of the tributaries. And we said, ultimately, no. The flow records aren't good enough. The priority situation is too complicated. The management and the operation of each of the tributaries is different. And we don't think that it makes sense to disrupt all of the existing understandings on the tributaries that there are, to say, okay, you've got to manage Rock Creek to spit out 111 CFS. I'm making that number up, but we just didn't think that that was a practical way to go about it. That we'd essentially then be having to play favorites among the tributaries and which water rights we're going to pick over others, and we didn't want to go there. Which again is why we like the idea of deferral period, so folks, if they can, either on a trip-by-trip basis or up and down the system, can see if there are ways similar to what's happening on the Blackfoot that folks can come to a general understanding.
How much of this was brought up due to tearing the dam down?
All this is brought up to the tear of the dam. I mean, if Northwestern or PPL or something was still running that dam, we wouldn't have the water. We have a whole bunch of different issues with the dam, but it's a major safety dams problems, contaminated soils and all the other reasons they ultimately did pull the dam out and do the restoration. But if the state hadn't acquired the Milltown right, we'd have needed to do something else with the CSKT and the Upper Clarkford, because irrespective of whether that dam is there or not, they've got legal claims to water like this one. So we frankly thought that it was fortunate that the state already had the Milltown right, because otherwise, if we were trying to deal with that hydro right, as well as all of the existing consumptive users, it'd have been that much more complicated to try to come to a settlement with the tribes that would be politically viable for both sides. Because the settlements that we do, they got to go through the state legislature, they got to go through Congress, they got to go through the tribes, and then they got to go to water. So there are multiple political and legal checks along the way, and we're trying to get to the first of those by getting to the legislature this January. But like I said, we looked at what we thought the impacts would be. We looked at storage facilities. We took a look at Georgetown, and we took a look at East Fork, and ultimately, what we see is we don't see this affecting Georgetown at all. The rights over there are hydro municipal. We don't see irrigation rights up there, and as a result, nothing in Georgetown's not called. East Fork's an interesting one, and the East Fork's DNRC project, and they changed the purpose of that water right to market. That is not purposed as an irrigation right, even though they market the water predominantly for irrigation use. But our position is that under the terms of the settlement, that East Fork water right that the NRC has shouldn't be called. I could see there being a situation where the tribes or FWP might want to fight over that, and so I don't think we're going to be able to make a specific provision in the settlement that says East Fork's not callable. But we do have the language in the settlement that if the water right, if the purpose of the water right is not irrigation, it's not callable, and we think that covers East Fork.
That's amazing.
Yeah, you know, I mean, Willow's irrigation, and so Willow potentially is susceptible to call. But what that means is that it doesn't mean that once water is stored, it's out of the priority system. So anything that gets impounded, if the water right isn't called to stop the water from impounding, that's in, and that can't be taken away. So if they're storing water during runoff, and that water's in behind the dam, the tribes or FWP can't come along in July or August and say, okay, it's dropping now, you gotta release water for this. That's not how the priority system works in Montana. Theoretically, if they're storing water during a lower flow period, then the tribes or FWP might be able to say, hey, you can't store that water, you gotta pass it through so that it flows down to us. But that doesn't affect the most productive storage seasons. So we think that the practical impacts even for Willow should be pretty good.
Kind of, well, I can still remember the question. So if we get in a situation of the spring off in here where Flint Creek is essentially dry, so you're gonna prioritize water rights to where we can store hydro water in Georgetown Lake, which places added burden on senior rights downstream.
Well, if you're looking at the spring, then the spring really shouldn't matter.
Yes, it does.
Well, no, I mean,
The hydrograph, it does.
no, it matters to the hydrograph here, but it doesn't matter to the
Yeah,
hydrograph
it
in
does.
Turk.
It does.
Doesn't? Because I mean, the flow statistics we ran. We're seeing a Turk.
And, you know, even if it doesn't
Yeah.
affect, which there has been a couple occasions when it does.
Okay.
You know, and they may just be anomalies, but you're suggesting changing our appropriations doctrine.
We are suggesting in this compact for this particular purpose, we are indeed talking about looking at different categories of beneficial
You're
use.
prioritizing
Montana historically has never ever done that, absolutely. And the legislature's been very consistent that they do not want a hierarchy of beneficial use.
Do you see an issue in the upcoming legislation with that?
I see some concerns being raised,
I mean,
absolutely.
I'm not,
No, I mean, I think that folks will have concerns about that because I think that folks will look at that with reason that this is the beginning of a slippery slope.
that's the
Yeah,
point.
you know, and we recognize that. Our response to that is we are not talking about issuing new permits. We're not talking about a growing communities doctrine. We're not talking about saying if you're coming in asking for one kind of water use, you get preference over someone else coming in and asking for some other kind of water use.
But-
What we're doing here in the very unique and specific context of an Indian water rights settlement. And historically, if you look at the compacts that Montana has done, we've been able to do things in our water rights settlements to get those settlements politically palatable for everyone, that as a matter of statewide water policy.
Not only is it an Indian issue, but it's a fish, wildlife, and parks issue, it's a state of Montana issue too. That's the more scary part to me.
No, and I get that. And ultimately, we're willing to bring fish, wildlife, and parks to the table in this way on this specific right because we didn't see better alternatives. You know, our mission as the Compact Commission is to come up with these water rights settlements and to do it in a way that protects existing users to the greatest extent possible.
I don't have an alternative for you either.
Right. No, I mean, it's a legitimate concern. We've certainly heard it voiced. I mean, I was in Deer Lodge last week talking to the Powell County folks, and they're certainly concerned for their irrigators, and they don't love the precedent either. You know, I've been talking to Crystal Lee Evans, who represents the Senior Water Users Coalition, and she's concerned. Jay Bodner from the Stock Growers. I mean, the folks who are looking out for, actually, John Youngberg from the Farm Bureau, rather, is the one who is more concerned. You know, people who are looking out for the ag interests are concerned about this because this is definitely something different than Montana's been willing to do in the past in terms of picking out certain categories of use you can enforce against. And our response to that is like I said, that yep, we are aware that we're doing that, and we are aware that it is different, and we are aware that because of the concern about the precedent it sets, it makes folks nervous. And what we're saying is that we think that this situation is sufficiently unique, and frankly that at the end of the day, the legislature, which historically has never been willing to go in a prioritization of beneficial use direction, isn't likely to be any more willing to do so in the future, irrespective of what we do here. That we understand the concerns. We don't think that they are significant enough as compared to the other things that we're trying to accomplish here to push us in another direction that frankly we haven't identified, but that in all likelihood would have broader disruptive effects across western Montana than what we're trying to do here, where we're trying to pin those effects down real tight.
Could I ask a couple more questions? I need to leave before too long. The Murphy rights,
Yep.
that on Blackfoot and on Rock Creek.
Yep.
I know there's been, I'm not part of it, but I know there's been a lot of concern in the Blackfoot concerning the Murphy rights and priority dates.
Yep.
Won't this effectively make the Murphy rights a 1904 right?
It doesn't. The Murphy right will stay as the 1971
But
date.
what relevance does it have?
Right. Well, in part, the Murphy right still has relevance because that's what's measured down near the confluence with the Clearwater. So in terms of reach, as I understand it, it's measured higher up the system.
But
So
again-
reach by reach, not much, but certainly this sitting there at the bottom of with a 1904 date potentially brings some new folks into the Blackfoot Challenge who presently are not part of it because their rights may be subject to call.
Right.
Absolutely. We were up at a Vando about a month ago. We've been talking to some of the Blackfoot Challenge folks, to Land and to Brian and to Jim Stone. And everyone, and the tribes were at the meeting at Vando, as was Fish, Wildlife, and Parks. And both of them, as the prospective owners of this Milltown right, are very clear that they are not interested in doing anything to upset the apple cart on the Blackfoot Challenge. And we're clear about that because at the end of the day, we need to take this thing not just through the Montana legislature, but through Congress. And the Blackfoot Challenge folks have shown a very good ability to leverage money out of Congress. And between our congressional delegation and between national lobbying groups like the Nature Conservancy, which has put a whole bunch of money into that Blackfoot Challenge, if we were to show up in DC with the water rights settlement and said, oh yeah, by the way, this could mess up the Blackfoot Challenge, we're not getting out of DC. And so part of the reason the tribes proposed the bifurcation of the 7 and the 5 was that 700 CFS number is identical to the Murphy rate number.
Yeah.
So at a flow target, it's a number that the Blackfoot folks are already used to dealing with.
So, in theory, there may be no change, but the priority issue is still there.
The priority date issue is still there, and that means that there may be some folks who currently are not part of the challenge,
Right.
who may either need to come in or take their chances in priority.
Again, now you're changing some more water law.
We're not changing water law on
Yeah.
that one. In fact, no. In fact, on this one, we are being very careful not to change water law, in that this water right retains the date that it has.
Rock Creek, and I'm not terribly familiar with that Murphy, right? Was it 200 CFS? I don't.
I'm not even sure off the top of my
I
head.
don't remember for sure.
I can pull the numbers.
And it's quite different than the Blackfoot situation. I don't know if it's even an issue. But
We
again, it's the same question though. It's gonna change priority dates.
Well, no, on Rock Creek it's not, because again, to be clear, this is true for Milltown, and this is true for the Murphys, and this is true for the recreation rights. Those rights are all staying as state-based water rights. They are not becoming Indian rights. They're not becoming Federal Reserve rights. They're not getting an 1855 treaty date. They're not getting a time immemorial treaty date. They retain, all of them, each individually, the priority date that they have under state law, the way that FWP filed on them in the adjudication, or with Milltown, the way that ARCO, or whoever it was, filed on in the adjudication. So we are being very careful not to change state water law in that way, which is that these rights, even though we're doing this as part of an Indian water rights settlement, even within the four corners of this settlement, these remain water rights that are state law-based water rights. We're quantifying other rights for the tribes that are Federal Reserve rights, but these are not, and we're not changing them.
Something you might not be aware of that, my dates are, it's a long time ago, but I think it was in '84, there was a reserve water rights, not reserve, it was a water reservation process on the Upper Clark Fork. certainly Fish, Wildlife, and Parks is changing. They are now they're acquiring in-stream flow rights on the Clark Fork.
The rights, yeah, I mean, they're acquiring rights on the Clark Fork, but they're doing that outside the context of the settlement. Nothing we're doing
Doesn't
is.
matter, this is between
No,
the state
right.
and
No,
the parties.
I hear you on that.
That
and
needs to be resolved.
I don't think that we're gonna resolve that in our process, because my understanding of the history, and I think you know it better than I do, my understanding of the history is that in part, it was that push to start the west of the Divide Water Reservation process
Yeah, well,
that led to the legislative closure of the Upper Clark Fork.
actually, I was part of it. I'm divulging my age here a little bit. That process started because of an upcoming contested case hearing between Fish, Wildlife, and Parks and the Granite Conservation District over, and it was a lot bigger than that because it was in-stream flow versus irrigation rights.
Sure.
I mean, the whole basin was involved to a degree. But that agreement was a tough one to push through. The legislature closed the basin. Had to be involved in that. And there's enough people that remember that this kind of flies in the face of that agreement.
I think I'm gonna need to disagree with you on that a little bit, in that this really is something discrete from that agreement, in that what Fish, Wildlife, and Parks has is this Milltown rights come in one way or another because of the natural resource damage litigation. And the rest of the Fish, Wildlife, and Parks pieces here.
Fish, Wildlife, and Parks wasn't required to take the
No, but the natural resource damage program did, and as I understand the state's intention is to hand that off to Fish, Wildlife, and Parks
And the
as the
process by
fish
which they're
agency.
taking is legislative rather than going through a change process.
Correct.
And that's going to cost.
It'll cost-
It's a concern.
Sure. No, and
But it needs to
absolutely.
be dealt with. I think it needs to be fleshed out a little bit.
Well, I think that we're trying to flesh that out by explaining how we're gonna have this right legislatively changed. Because at the end of the day, there's not a way to flesh out what it's gonna look like on the other side of the administrative change
That's
process.
true.
If it goes through the DNRC change process, one, you never know politically what's gonna happen to it. And some of that frankly may depend on who the next governor or the next attorney general is and what they wanna do with it. But the terms of the consent decree are that the state can't do anything to diminish the value of the right. So even if you've got a governor and attorney general who are less interested in seeing that right come through as an in-stream flow out the other side, they're still bound by the terms of the consent decree. We violate the consent decree. I'd have to go back and look at it again, but my guess is that right will end up in the tribe's hands anyway.
Well,
And then if they take it through the change process, there are none of the restrictions I'm talking about on the enforceable levels. And I know folks like to make the argument that because the dam owner never made a call on that right, that somehow they've lost the ability to enforce it. That's certainly not consistent with my understanding of Montana water law. And looking at the flow records
No,
that dam has, that dam's got some of the best set of flow records in Montana, because they can tell you every single day it was going through their turbine. And if you look back over the period of record, you can find every single calendar day of the year. Not in the same
Yeah,
year,
well,
but every
yeah.
single calendar day of the
Yeah,
year,
just-
2,000 CFS went through those
probably as
turbines.
good a record as you find anywhere.
Exactly. And so our sense is that although it might become a political football to get through the DNRC change process, and it could take 2, 3, 4, 5, 6 years, they'll come out the other side with an enforceable 2,000 CFS right, which is more disruptive than what we're proposing to do with the settlement.
Is the duty to provide water for the 1,200 CFS, is that still under negotiation? Which Clark Fork, Blackfoot,
What's in the draft document right now is the 700 at measured at bar
7 and 5,
and the 5 measured at turn. That's what the state and the tribes have provisionally agreed to for purposes of putting a draft settlement out the door. And let me be really clear about that, which is that we're not putting this out the door saying, you know, we're done, we're kind of going through a public review charade, but we've decided on how this is going to be. That is not what we do. That is not how we operate. And if we tried to operate that way, the legislature would kill this thing anyhow.
yeah.
We are very, very clear that what we put out the door last week for public review is essentially our provisional first shot. This is something that we think is a reasonable basis for settlement, but we need to hear from the public whether our sense of that matches up with the public sense of that, whether there are things that we can try to address that need to be, whether things that need to be addressed, whether things that we can address, and ultimately, you know, how close we came to the mark of something that's going to be viable in the legislature. because that's the end game.
And maybe, I don't know, I'm reluctant to even bring it up, but, you know, I've watched the gauging at Tura. And this summer, it's in September, it's been running 1100. We're, more than double where we're reaching call levels.
Yeah.
And the Blackfoot is below 700.
Yep.
Now, was that part of this, the formula for this? That one kind of worries me a
We
little bit.
recognize that could happen. The Blackfoot and the Clark Fork are sufficiently different drainages that, depending on the nature of your precip and the nature of even where your rain falls, that you could get wildly fluctuating
Well, a little bit
flows.
of me says, you know, it's been dry this
Yep.
summer. I mean, this has been as bad a drought for irrigation water in this part of the world anyhow as we've seen in a long, long time.
Yep.
And yet, we're way above the call level at Bonner, at
Sure.
Tura, excuse me. But the Blackfoot, they have reached it this year. I don't know if they made a call, the Murphy Rice, I don't know how that worked.
Right, well,
That's-
as I understand what happens on the Blackfoot is that essentially that Murphy Right's the trigger for the various
Yeah,
adaptive
yeah,
pieces
they've
that
got
go
a
in.
system
And
up
so I
there.
believe that they did invoke
probably
their
triggered
adaptive,
that,
they
I
triggered the
assume.
adaptive management, but because they've gotten the drought management plan in place, it's not a formal call-making thing.
But I see a real possibility of a conflict between the two sources. And
Well-
that's why I wonder if it's, at some point, do we start changing those numbers?
Well, I think actually that we believe that by having the discrete numbers, each one callable of a system, that actually eliminates the prospect of conflict. Whereas if you're looking,
Yeah,
I mean,
but-
if you were looking at 11 or 12 down at
Just that
the
below the dam,
confluence,
yeah, that's.
or if you're 11 or 12, if you're 12 below the confluence, you're fine. But let's say you're at 9 below the confluence,
Mhm.
and Tura's running at 11 and Bonner's running at 5. If we're measuring at the confluence and we don't have the contribution
Right.
targets by major drainages, theoretically, the tribes or FWP, instead of making that call up to Blackfoot, could say, even though you're running high at Tura, we need the rest of our water down here at the confluence, and we just as soon get that out of Flint Creek as up the Blackfoot.
Right.
I mean, that's the situation we wanted to preclude, which is why we think that the idea of bifurcating the targets is actually a really good
Oh,
one.
I do too, I agree with that.
Yeah,
That's-
and why the 700 number is the right number for Blackfoot, because that's the number they're
Already
using
have
to
that
deal
number,
with.
yeah.
Exactly.
Yeah, you already have that number, and the 500 seems like a good deal for the upper Clark.
Yeah, I mean, honestly,
Quite honestly.
that's how we looked at it. I mean, we really wanted
The only
to
thing
try.
that troubles me about it is you talk about your availability curve, and you're looking at 2,000 CFS.
Yep.
What does that do for development?
Well, what it does is it puts a crunch on development, but I think that crunch is there either way. I mean, that's the Milltown right, and frankly, even if we had the enforceable level of 12, it's still a crunch on development because, as you know, as irrigators, water's tight, and bringing new uses on without mitigation, and that's what it means.
Yeah.
Bringing new uses on without mitigation is gonna, in all likelihood, cause problems for a whole bunch of existing
Well,
folks.
yeah, probably.
And that's the only place that the legal availability analysis comes in, which is whether you can meet the 311 criteria, the new permit criteria, or whether you need a mitigation plan to get your new permit.
And, I can really only speak from the irrigation perspective, and being singled out as the source
Yeah.
is a little bit of a concern.
Sure.
I said, wait a minute, but where are the municipalities, Anaconda, Deer Lodge, Butte, where are they coming in on this? And their concerns are much more about development.
What I heard from the Powell County folks when I was in Deer Lodge last week was mostly the concern you're echoing about irrigation. Because what they heard me
Yeah,
say...
I realize, but have you
Well,
heard from the
what
municipalities?
they heard me say is that the non-irrigation rights are protected. And they seem to think that
Yeah, but the
was reasonable
development
for
rights
Deer Lodge.
aren't. But the development rights are.
No, but they didn't really seem too concerned
Okay,
about
I
that.
just-
And I'm going to be in Anaconda at 6 o'clock tonight.
Yeah,
and
well,
I'm
just out of
talking-
curiosity,
No,
I mean-
it's a good question.
The upper Clark Fork is much different than the Blackfoot in that respect.
No, absolutely. One of the things, though, that to some extent protects the municipalities, is there is a quirk in Montana water law that essentially allows municipalities to hold on to more water than they're developing as long as their intake facilities are bigger.
Yeah, right.
Even if they're not diverting to the full capacity of their infrastructure, they're allowed to protect in the adjudication to the full capacity of their infrastructure. And so I think that that's been helpful for those those folks, frankly, I would assume, I mean, I'll find out from Anaconda tonight.
Well, they know much more about it than I do.
Yeah, and I expect the Butte folks would be fine. I mean, they're looking to offload some of their Silver Lake water. So I think they got a sense that they got more than they need for their municipal uses right now. But we
No, they
plan,
don't.
well, we plan to be getting with the Butte Silverbow folks as well.
Yeah.
We've been trying to get with Senator Sesso, and we want to talk to the city county folks also. But our sense is that what we're really doing here is the future development piece is all constrained by the legislative closure anyway. And that all we're doing is essentially preserving the status quo on that, which is that this is an existing right just like everybody else is an existing right. And so if you are going to be making the permit findings for new permits in the absence of mitigation, you just got to take this right into account as well.
The legislative closure does allow for storage.
And we're not
I think-
precluding that.
And, yeah, you are.
Well,
I think you probably are.
Not during runoff. I mean, if you look at the runoff, if you look
Yeah,
at the runoff hydrographs,
well, you're putting a level of, on that process.
absolutely.
That's.
No, certainly that's true, but what I would slightly dispute your characterization that we're putting something new on it, because that Milltown right is there. And that Milltown right is there one way, and that's an existing right, and what we're trying to do is to use that existing right to settle the other problems we have in this negotiation. The choice isn't between the status quo minus Milltown and what we're doing.
Now, and
The choice is between that Milltown right coming online that FWP is going to
we could
have.
probably get into hours of argument
Sure.
about water rights and, that sort of thing, and that's not the point here. Appreciate the chance to.
No, Jim, I
ask a
appreciate your
couple
attention to this, and I certainly respect your concerns. I expect we'll be hearing more from you and from your folks. But I mean, just to circle back to your key point, what we are proposing to do by singling out irrigation for call is new and different, and I can certainly recognize why that freaks some folks out. And I think there's good reasons for folks to be
Several
nervous.
levels of that.
Sure. No, and that makes a lot of sense. But again, our response to that really is that what we're trying to do is to find a pragmatic solution to what otherwise is a problematic legal situation. And we think that this is an important component of that. And we think that it really doesn't crack that door open very wide for future assaults on irrigation rights, because we're doing this in the very unique context of an Indian water rights settlement and in the very unique context of trying to preserve folks' relative priorities rather than sticking a new right at the head of the system. So again, I would say the choice isn't so much between the status quo of no prioritization among beneficial use and what we're doing here, as much as it is between the prioritization that we're doing here and the tribe sitting at the head of the queue with a very large non-consumptive in-stream flow right that they can look at everyone in the basin and say, shut off, shut off, shut off.
Well,
He's a guy has to have a lawyer sitting right with him.
you do.
Yeah.
That's the truth.
Yeah.
Well,
It's a lot of complicated stuff. There's no two ways about it. There's no two ways about it.
What else brought this on? Who brought this on?
Honestly, the Constitutional Convention in 1972 and the Montana Water Use Act. The Constitutional Convention required the state to have a centralized repository of water rights. And what we all looked at who were around in the early 70s is that we didn't have one because we had scattershot district court records. And so that led to the adjudication. And Montana passed the adjudication statutes as part of the Montana Water Use Act and said that we are going to quantify every single water right in the state of Montana. And we said as a state, okay, and that's got to include federal and Indian water rights. And the tribe said, hell no, you're not going to adjudicate our water rights in state court. And we said, yeah, we are. The United States government, the McCarran Amendment in 1952 said we could. And the tribe said, no, you can't. So that got resolved by the U.S. Supreme Court in 1983. And they held that, yep, McCarran did in fact waive tribal sovereign immunity to bring Indian water rights into state court. And then the CSKT sued us right after that, 1983, and said, well, McCarran might let you do it, but the Montana Water Use Act on its face is not McCarran compliant. And we said, yeah, it is. And they said, no, it ain't. And in 1985, the Montana Supreme Court said, yeah, it is. And so ultimately, that's why we're doing this, because that's what the legislature commanded the state to do through the adjudication. And the legislature at the same time made the determination that it was going to be better for everyone to try to negotiate these Indian water rights rather than having them get called in when they call in the basins like they do the rest of the adjudication. So that's why we're doing this. It's it's certainly not something that we chose to do for the hell of it, or because we wanted to make your lives more difficult. It's yeah, I know we are. I know we are. I don't expect to show up and be well liked. That's not what I'm down here.
I think I'd wear a flak vest if I was you.
Nah, I got very thick skin. You know, but no, I mean it's that's the nature of it. I mean I tell this to people and they think I'm kidding the first time I say it, but I realize I'm not. But a negotiated settlement means everyone goes home unhappy. Yes, ma'am.
How does this affect, or will the draft that was recently released, the Upper Clark Fork River Basin Aquatic and Terrestrial Restoration Plans, how is that going to affect, how is this going to affect that, or how is that draft going to affect this negotiation?
Those should operate independently because, as I understand, the restoration plan is a plan where they want to spend the money that the rest of the money the state got as part of the same natural resource damage litigation that brought us the Milltown right. And so people have put in requests for where that funding ought to go. I believe the governor's planning on making those decisions before he leaves office. And those are all funding questions that go into various restoration efforts. And those are independent of what we're doing here, which is simply a water rights question. This is about trying to settle some water rights claims, and it's not about actually providing restoration. It's not dealing with water quality. It's not dealing with soil quality. It's not dealing with terrestrial enhancements. And so, although it's operating in the same geographic area, they're really two distinct processes. It may be that some of the things that are done using that money may help with hitting the targets for this in-stream flow. I know folks are looking at Silver Lake as a possible source of augmentation water. And depending on how that plays out,
Already is.
yeah, in part. But if it's, you know, I mean, so that may be something.
And then is
Otherwise,
that,
we're not messing with that, and that's independent from us.
and that, but the Flint Creek is involved in that, right? And the wildlife and the riparian and Flint Creek is part of the Clark Fork Basin, so I don't know how they're independent of each other. It's going to affect the irrigation and use of the water, isn't it?
I don't know enough about the restoration and the funding pieces to know exactly which projects are being considered or which are going to get funded. But ultimately,
And Maureen,
What?
being as how you're aware of it, how much money is being set aside for acquisition of water?
That's yet to be determined.
That's yet to be determined. I heard a figure at the area meeting last week, and I kind of actually wanted to confirm that, which would sort of begin to tie things together. They talked, John Hollenbeck mentioned that they were setting aside $10 or $20 million for water acquisition. You think it's complicated now?
no, it may get more complicated.
That's the state's proposal
Is it?
on that.
Okay.
Yeah, that has.
Sorry, I'm trying to change the subject here, but it's.
Yeah.
Well, that's
you're
part of,
asking.
that's
Yeah.
part of that.
That's the, that is proposed by the NRDP staff. It did come in as project abstracts, which was what the point was. Okay, I have a couple questions.
Sure.
I need to run. Excuse me, thank you.
Jim, thanks very much.
After Jim gave me the workout there, I've completely forgotten my questions, Jim. Hopefully I wrote them down. If we can go back to hydro in
Sure.
Georgetown. I think that you said something that was kind of interesting to me, which was based on the right to store, and that's kind of what I'm trying to get at. For example, today, exactly, real life, real time, we are not storing water. But if we had a big gob of rain, it would very quickly switch into a storage situation with the outflows that we have going right now. FWP, I think, and with some of the litigation on Georgetown, there's a school of thought that the reservoir should be always at the rim and that the outflows should always match the inflows. And that is a school, it's a school of thought, that's not a legal situation. But I am concerned about, you you say hydro will be exempted, so that's while you're storing, or while you're not storing?
It's either
or
one.
all the time?
It's hydro is simply not callable. So if what you are proposing to do is to store water under a hydro rate, the Milltown rate, even if you got a rain event tomorrow and you were storing water up into Georgetown, and let's say the Turra gauge was at 460. Under what we are proposing here for the restrictions on the exercise of the Milltown right, the owners of that Milltown right could not call the Georgetown right, even if it's junior in the Milltown right, to say, hey, you got to let that water flow out. Any other water right holder who is senior in the Georgetown right theoretically could, but the Milltown right cannot. And that again is part of the sideboards that we're trying to put on the Milltown right because we're doing this in the water rights settlement, try to minimize the impact to existing uses. If FWP comes through the DNRC change process with this water rate, it wouldn't have those restrictions, so theoretically we could potentially stop Georgetown from storing. And potentially stop Georgetown from storing if the gauge of the confluence is below 2,000 CFS. But under what we're proposing here, they couldn't.
What about, the, 2000, okay, back to the proposal, the 1,200, 700, 500,
Yep.
10-year deferral. Talking about that, what's the season on that?
There's actually, there's a hydrograph, and that's part of the technical document, which is
Okay.
appendix
I'll read it.
7. Because what it actually is it's essentially, there's a hydrograph that tracks it. So the maximum enforceable level is 1,167 CFS at Bonner and 833 CFS at Tura during high runoff. And basically what we see is that gets hit every year automatically. And by the way, since that's happening during runoff and not during irrigation season, if the irrigation rights aren't turned on yet, there's nobody to call anymore. So as a practical matter, that number,
But irrigation rates would be turned on if it was May 15th typically.